Just sign here, sweetheart. It's routine paperwork to consolidate the family accounts before your birthday, my mother said, sliding a thick document across the kitchen table 3 days before I turned 29. I'd already read every page of it the night before, from a copy I wasn't supposed to have access to yet. I signed nothing that day. Instead, I asked her a single question, calmly, watching her face for the answer I already knew was coming. Why does this document keep referring to me as a beneficiary rather than your daughter? She didn't answer. But her silence told me everything the letter sitting in my desk drawer at home had already confirmed 3 days earlier. To understand how I ended up one step ahead of my own parents at exactly the moment they needed me least prepared, you need to know what arrived in my mailbox on an entirely ordinary Tuesday. 4 days before that conversation, my name is Julia Hartwell. I'm 29 years old, and until 4 days before that kitchen table conversation, I believed without a single moment's doubt that Richard and Elaine Hartwell were my biological parents. I grew up in a comfortable, unremarkable household, an only child, close enough with my parents that the idea of investigating my own origins had simply never once occurred to me across 29 years of life. I work as a compliance analyst for a financial services firm, a job that involves exactly the kind of careful, methodical document review that would eventually matter enormously in the days that followed. I want to be honest that this profession is precisely why I noticed something most people might have simply signed without a second thought. The letter that started everything arrived from a law firm I'd never heard of, addressed specifically to me, referencing something called the Ashford family trust, and requesting I contact them regarding a matter of beneficiary vesting tied to my 29th birthday. Want to walk through what I did in the days immediately following that letter, because the sequence matters. I didn't mention it to my parents right away. Something about the formal, careful language of the letter, combined with a name Ashford that meant absolutely nothing to me, made me want to understand what I was looking at before bringing it to anyone, even my own mother and father. I called the law firm the following morning. The attorney who answered, a measured woman named Constance Ferris, asked before saying anything further whether I was aware of the circumstances of my birth. I told her I wasn't sure what she meant. There was a pause on the line long enough that I understood, even before she said another word, that whatever she was about, to tell me would change something fundamental about how I understood my own life. What Constance explained to me over the following hour reframed 29 years of memory into something I am still honestly working through the full weight of. I had been born to a woman named Margaret Ashford, the only daughter of a wealthy shipping industry family who had died during childbirth. My biological father, according to Constance's records, had never been formally identified or come forward, and Margaret's own parents, my biological grandparents, had been elderly and in declining health at the time of her death, unable to take on raising an infant themselves. Rather than placing me through a conventional adoption process, my biological grandfather, Harold Ashford, had apparently arranged, through private legal channels, for a closed, informal adoption with a couple he knew through business connections, Richard and Elaine Hartwell. As part of that arrangement, Harold Ashford had established a trust in my name, structured to vest fully and directly to me upon my 29th birthday, a specific age he'd apparently chosen based on a family tradition of financial independence tied to that milestone across several generations of Ashfords before me. Critically, the arrangement had specified that the Hartwells would serve as trustees managing the fund on my behalf until that vesting date, receiving a modest annual management fee for doing so, but with no legal claim whatsoever to the trust principal itself once I turned 29. I want to be honest about the strange, dissociated calm that settled over me hearing this, similar, I imagine, to the way people describe shock in the moments immediately following an accident, before the full pain registers. Constance explained that the trust, after 29 years of careful investment management, had grown to just over $3.4 million, an amount considerably larger than the modest management fee my parents had apparently been receiving annually would have suggested to anyone examining our family's finances casually. I asked Constance the question that mattered most to me in that moment. Had my parents, the people who raised me, always known the full details of this arrangement? She confirmed they had. They had signed the original trustee agreement themselves, nearly 3 decades earlier, understanding fully from the very beginning that the money was never theirs, and that it would transfer entirely and irrevocably to me the moment I turned 29. I want to walk through what I did over the following 3 days, before that kitchen table conversation, because this is where my professional instincts, the same careful document review that defines my actual job, became directly relevant to my own life for the first time. I requested, through Constance, copies of the trust's annual accounting statements going back as far as records existed, along with the original trustee agreement my parents had signed 29 years earlier. What I found, reviewing those documents with the same methodical attention I bring to compliance audits professionally, was a pattern of increasingly aggressive fee structures over the past 6 years specifically, management fees that had crept from the modest, reasonable percentage originally agreed upon to something considerably higher, along with several transactions in the past 18 months moving trust assets into investment vehicles that, structurally, appeared designed to make the fund's true value more difficult to track and potentially easier to consolidate under a restructured management arrangement. I called Constance again, this time asking a more pointed question. Had anyone recently contacted her office regarding modifications to the trust structure ahead of my vesting date? She confirmed that yes, my parents' attorney had, in fact, reached out 3 weeks earlier, proposing what he described as a family wealth consolidation trust, a new legal vehicle that would have restructured the Ashford Trust's assets into a jointly managed family fund, with my parents named as co-trustees alongside me indefinitely, rather than the assets transferring to my sole, independent control as the original 1996 trust document specified. Constance had, appropriately, declined to proceed with any such restructuring without direct confirmation from me as the actual beneficiary, which is precisely why the original letter had been sent to me directly rather than simply routed through my parents as it apparently had been for the previous 29 years of routine trustee correspondence. Retained my own attorney, a careful, thorough estate litigation specialist named Robert Chen. The same afternoon, I finished reviewing the accounting statements, 3 full days before my birthday, and before my parents had any indication I knew anything at all. Robert's assessment was direct and frankly sobering. The fee escalation pattern over the past 6 years, combined with the timing of the proposed consolidation trust arriving specifically weeks before my vesting date, suggested a deliberate, coordinated effort to convert what should have been my full, independent inheritance into a permanently shared arrangement, one that would have given my parents indefinite ongoing control and financial benefit from money that, legally, had never actually belonged to them at all. I want to be honest about the emotional complexity of preparing for that kitchen table conversation. Knowing what I now knew, while my parents remained entirely unaware I'd learned any of it, Richard and Elaine Hartwell were, in every practical sense, the only parents I had ever known. Whatever their financial intentions regarding the trust, they had also genuinely raised me, showed up for every ordinary milestone of an ordinary childhood, built 29 years of memory that didn't simply evaporate because I'd learned the money underneath our family's stability had never actually been theirs to manage the way they'd apparently begun treating it. I decided, with Robert's guidance, not to confront them immediately with everything I knew. Instead, I waited for them to bring the consolidation document to me themselves, which, based on the timeline Constance had described, I understood would likely happen within days, given how close we were to my actual birthday and the trust's automatic vesting date. The kitchen table conversation happened exactly as I expected. 3 days before my birthday, my mother presenting the consolidation document with the same casual, practiced warmth she'd probably used countless times over the years managing routine trustee paperwork I'd never once thought to ask about. I asked my single question, about why the document referred to me as a beneficiary rather than simply as their daughter, watching her face carefully as the calm, practiced explanation she'd clearly prepared visibly failed to materialize. My father, entering the kitchen partway through the silence that followed, asked what was happening. I told them both, calmly, that I already knew everything. The Ashford family, my biological grandfather Harold's original trust arrangement, the escalating management fees, and the consolidation document's actual purpose: to convert my independent inheritance into something they would continue controlling indefinitely, timed specifically to arrive before I ever had reason to look closely at an arrangement I'd never once been told existed. I want to be honest that what followed wasn't a dramatic confrontation so much as a long, difficult, painful conversation, spread across that evening and the following 2 days, working through 29 years of a relationship that had been, in ways I'm still fully processing, built partly around information deliberately withheld from me for reasons that, based on the financial pattern Robert and I had already documented, appeared considerably more self-interested. In recent years than my parents initially wanted to admit, my father eventually acknowledged that the escalating fees over the past 6 years reflected mounting financial pressure from a failed business investment he'd made without telling my mother the full extent of pressure that had, apparently, made the prospect of permanent access to a $3.4 million trust considerably more tempting than it might have been earlier in their trusteeship, when the arrangement had operated, by all accounts, honestly and as originally intended for over 20 years. The trust vested to me in full, exactly as the original 1996 document specified, 3 days after that kitchen table conversation, on my actual 29th birthday. Robert ensured the consolidation proposal was formally withdrawn and that a full, independent accounting audit of the past 6 years of trustee management was conducted, ultimately identifying just over $140,000 in excessive fees my parents had collected beyond what the original agreement's reasonable management percentage would have allowed. I chose not to pursue formal legal action over that amount specifically, a decision Robert respected but gently questioned given the strength of the case. I want to be honest that this decision wasn't about excusing what they'd done. It was about deciding for myself what kind of relationship I wanted to try to preserve with the only parents I'd ever known, separate from holding them fully financially accountable for a plan that ultimately never actually succeeded. My relationship with Richard and Elaine remains genuinely difficult, still actively being rebuilt nearly a year later, in ways that don't erase what I learned, but also don't require abandoning 29 years of a relationship that, whatever complicated financial motivations emerged in its final chapter, also contained real, ordinary love throughout most of it. I established contact, separately, with my biological grandfather's remaining family, distant relatives I'd never known existed, people who, upon learning the full story, expressed both sorrow over decades of lost connection and genuine relief that Harold Ashford's original intentions for me had ultimately been honored. Despite a late attempt to redirect them, I think often about the specific detail that made the difference in this story: a letter arriving directly to me, rather than being routed through my parents as apparently every other piece of correspondence about this trust had been for 29 years. I don't know if my biological grandfather anticipated, decades in advance, that his own specific instruction, that vesting notification go directly to the beneficiary at 29, rather than through the trustees, would end up mattering as much as it eventually did. But it gave me exactly the few days of lead time I needed to understand my own situation fully, before anyone attempting to redirect that inheritance ever realized I already knew. Sometimes being ahead of a plan against you isn't about outsmarting anyone in the moment. Sometimes it's simply about a piece of paperwork, drafted carefully decades earlier by someone who never got to meet you, quietly doing exactly what it was designed to do, right on schedule. If you've made it this far with me, do you think your reaction would have been to confront your parents immediately? Or do you understand why I waited those 3 days to let them come to me first? Let me know in the comments where you're watching from tonight. And if stories like this one matter to you, make sure you're subscribed to Justice Unfolds, because every story here has a reckoning.